Everyone, good morning. Good morning. Welcome to the ODPP Café. It's Friday, and we are here every Friday at 8 a.m. to bring to you the ODPP Café. The show is brought to you by the Office of the Director of Public Prosecutions, and it's meant to educate and inform you on matters of criminal justice, on the criminal justice system. So welcome, engage with us on our social media platforms. We are live on Facebook today, but again, you can follow us on Twitter and subscribe to our channel on YouTube. Like I mentioned earlier, our YouTube channel is Office of the Director of Public Prosecution. And on Twitter, we are at ODPP_KE. Facebook, it is just Office of the Director of Public Prosecution. Please engage with us as we go along. We will engage with you as well. We'll respond to questions as we can within time. And even offline, we'll still answer the questions that you will have. So today our topic is on appeals, and we'll catch up with this a bit later. Before that, we have a guest who is the head of appeals division at ODPP, and we are looking for an engaging discussion. In just a few minutes, I will first of all take you on a quick roundup of the courts this week. And I know you know this case about the 57 people who were arrested along Gong Road, I believe clubbing, most of them. And they were arrested for breaching MOH protocols on COVID-19. And they were sentenced to community service. And the reason I'm telling you this is because at the ODPP, the DPP is a proponent of non-custodial sentences because we don't want to have congested prisons with people who have done minor offenses like they did. But then point to note is that mask up, COVID is real, and you've seen the third wave is really harsh on us. So, and I know one of the reasons we survived the first and second wave is because we took heed on the protocols given by MOH, masking up, social distancing, and of course sanitizing. So those 57 people are still, I believe, doing their non-custodial sentence and cleaning up some places around the city. The next case is on an Ethiopian national who was convicted to 15 years in jail and a fine of 25 million he was found with cocaine, 2.1 kgs of cocaine with a street value of 8.1 million. So the guy was sentenced to 15 years and a fine of 25 million for that. The other case is on former Governor Mike Sonko. He was declared fit to stand trial. Remember, the defense kept giving excuses as to why he can't stand trial, but the court found him fit to stand trial in a case of 8.4 million, a corruption case of 8.4 million. The case is set to begin on 29th April, and hopefully it will go up until 1st of April. The next case is about two men who have been jailed for 200 years, and I will have my guest talk about that a bit. I don't understand it, and I bet you also don't understand it as a viewer there. So two men got 200 years in jail for robbery with violence. The incident took place in Kitale. Sadly, Brigadier Yator was robbed and murdered. So the courts found them guilty and jailed them for 200 years for robbery with violence. So that is what we have and I know a lot has been happening in the courts, but that's just a sneak preview of what has been happening in the courts this week. And of course, we'll keep updating you as this go on. Follow us on Twitter as well and Facebook. We keep updating what goes on in the courts as we get the information. So away from the courts, some news again from the ODPP. The DPP launched a project in Lamu yesterday. The project seeks to strengthen the criminal justice system, the capacity to effectively investigate and prosecute commercial sexual exploitation of children. This was done in Lamu yesterday, of course, with some criminal justice actors. Today, he is in Kilifi, where they are discussing again with other actors and stakeholders on how to present individuals at a risk of violent extremism with alternative means to express their grievances and also to reduce their vulnerability to violent extremism. That is all from the courts and in the news this week. Coming up next is Semana Prosecutor, and in this clip, the DPP is addressing the subject you have today, though briefly, and we're going to just pick it up from there. He's addressing the question on appeals. This was done in one of the community dialogues that the DPP engages in, and it was done in 2019. So don't worry, it was not done during this COVID period. So it was done in December 2019. Just have a listen to it, and then we can now pick on the discussion and, of course, introduce our guest today.
What are some of the stages that somebody should follow for he or she to make an appeal?
Usually appeals have limits. Immediately when a matter is concluded and the ruling has been given, you have to make the appeal. Usually within a time frame maybe of 14 days. So hiyo ikilapse itakuwa ngumu sana. Lakini iko na hiyo limitation. Tuko sawa?
Thank you. I bet you've heard the DPP address a question on appeals. Of course, like I said, we'll discuss it further, a lot more in this segment today. So I am privileged to have the head of appeals division with us today, Hassan Abdi. I'll just give him a few minutes to introduce himself. Karibu sana kwenye kiti ya kufundisha watu mambo na law.
Asante.
Yes.
Asante sana, Anita.
Yeah.
It's a pleasure being here this morning. My name is Hassan Abdi. As you have stated, I'm the head of the appeals division in this office.
How long have you done this?
Well, I've been an advocate now for more than 20 years.
Okay.
I was in private practice before I joined this office. I have been in charge of this division for 3 years now.
Oh, good.
Yes.
Oh, good. Karibu sana. Like I said, the show is meant to educate people and to just break down some nuances of the law. And today you're here because you want to discuss appeals. Well, before we start that, I mentioned a case about 2 men who got 200 years in jail. I mean, who is going to live for 200 years? How is that even calculated? What does that mean?
I think it's important to understand what was the actual decision or the judgment in that case. I'm sorry, I'm not able to understand whether it was concurrently, whether that sentence was to run concurrently or consecutively. So
That's ukisema concurrently na consecutively
yes,
umetupoteza.
maybe the 200 years, as you have said, may be an accumulation of, sentences that have been meted out. In other words, when you're talking about consecutively, what that means is that when one sentence is completed, the other one starts.
Oh,
okay.
yeah.
So if somebody was convicted and sentenced, say, to 10 years on one count or one offense, then sometimes you also hear that in the second count or second offense is going to serve 5 years. On the third count is going to serve
so
2 years.
Okay.
So that, when you add up, these years, then you get an accumulative figure. So in that case, since I don't have the benefit of the details, the 200 years may be perhaps to run concurrently. In other words, we all know that you can't be in prison for 200 years. Yes,
that's possible.
So it's important to understand exactly what the judgment was all about.
Oh, okay. Good. So we get back to our topic. And the DPP addressed some of it in the Semana Prosecutor segment that we just had. But for the benefit of our viewers, the people online, what is an appeal process?
Thank you, Anita. The appeal process is a judicial examination by a higher court of the decisions of the lower court. That is basically what an appeal process is. In other words, the judgments or the decisions of the lower courts are subjected to the scrutiny by the courts above these lower courts, and to see whether those decisions are sound in law.
Okay, good. So, what would make someone want to appeal? What are the grounds for appeal? What would send a case to an appeal court, or now, what would make a case go through the appeal process?
Yes, in the criminal trial process, we have two parties.
Yes.
We have the prosecution on one hand, and we have the accused person on the other hand. So the decisions will normally be contested by either party. It's rare that you'll find there's a bit of concurrence in the judgment. Yes. Yeah. So it depends on who is the aggrieved party in this particular instance. Where there is a conviction, the accused persons will feel aggrieved. And therefore, there are many grounds which that particular convict can raise in instituting an appeal. For example, the convict or the accused person may argue that the trial court did not take into account his defense, where he put up one. He can also argue that the court took into account evidence which it ought not to.
Okay.
Another ground could be that the trial court failed to take into account material evidence which may have exonerated the convict. The sentence also passed may be, in his judgment or view, be too excessive, so that he feels that he was being punished severely, in line perhaps with the offense that he has been charged with.
So the question is, why would you want to wait for this process? Why would you wait for judgment to be passed, then you appeal? Why can't you just object and new evidence is brought, or whatever evidence you're disputing is thrown out? Why wait for it to, why take it to appeal to discuss this?
Now, the trial process is unique. You know, there are stages that one goes through in a trial process, that is a criminal trial process. We have what we call examination in chief. That is the first step, after somebody has taken plea and the case has been set down for hearing. This is where now the prosecution brings forth the case by lining up witnesses. So that process of bringing these witnesses by the prosecution is called examination in chief. Now, there is then an opportunity for the accused to test the veracity of that evidence through cross-examination. Okay?
Yes.
So it is through cross-examination that now that accused person is empowered or is allowed by law to raise issues and questions. In other words, to test the credibility of the witnesses and the veracity of the evidence that is being adduced. Then there is re-examination by the prosecution. Once the cross-examination is done, you have re-examination, where now the prosecution uses this opportunity to clarify on gray areas. So the trial process itself has unique features. And it is through these processes that some of the issues can be canvassed, where there are a bit of contradictions or inconsistencies here and there. It is through these processes that those ones are raised and, if possible, they are cleared.
Okay, so this is all in the Constitution. You have a right to appeal.
It is what the fair trial is all about.
Haki na usawa.
Mashtaka yenye haki na usawa.
Maybe a bit of that. Because I think your division is anchored on haki na usawa, right?
Yes.
Yeah.
There is this conception of, that the DPP is sole aim is to jail people, to convict people. A gladiator.
A gladiator,
who wants to see blood being spilled all over.
Yeah.
That is not the position. The DPP is a minister for justice. He's a zealot advocate, and his interest is the public safety and public interest. Therefore, in all that we do, public safety
comes first.
Is paramount. The public is our client. And the underlying philosophy is very simple, that the guilty must be held to account for their actions, and the innocent must be protected. Because whenever a crime occurs, we have victims. So who is there to protect these victims?
Okay, the DPP.
Yes,
Yeah.
the Minister for Justice.
The Minister for Justice.
In this case, the DPP.
Or the office of the DPP.
Yes.
Yes, yeah, represents the public. So public interest
because
comes
without bringing people to account for their actions, we will have no order in society. it is a recipe for anarchy. And respect for law comes because there are consequences for non-compliance with the
Of
law.
the law.
Yes.
Okay. Okay, thanks for that. So then we go back to our appeal process. So the courts have hierarchy. And I just before we started this, we're discussing about the Supreme Court and the Magistrates Court. So maybe just give us a bit of that. How is it, what is the court hierarchy?
Now in Kenya, we have the subordinate courts. Then we have the High Court. Then we have the Court of Appeal. Then
So
we
the
have,
subordinate courts are the magistrate courts.
they are magistrate courts.
Okay, okay.
Then we have the High Court, and then we have the Court of Appeal, and now we have the Supreme Court. But we also have the Qadhi's courts,
Yes.
which deal with the Islamic jurisprudence or affairs with respect to inheritance and divorce. And then we also have the court martials.
Which one is this?
These are courts that deal with the armed forces.
Ah, okay.
Okay. And as you know, the Constitution allows the DPP to commence, take over, and discontinue all criminal cases in this country except the court martials.
Okay.
So the court martials are a special category of courts.
Different. Okay.
But let me say this, that all these courts that I've talked about or I've mentioned are subject of the appellate system. In other words, decisions from the Qadhi's courts and also the decisions from the court martial are appealable to the courts above them, and that is the High Court.
The High Court.
Yes.
So you
That's
can
the
have
court
a
of the
court,
first
you can
instance.
have a case in the court martial courts and you appeal it at the High Court.
They are appealable to the High Court.
To the High Court.
Yes.
Okay. All right. Interesting. Okay, so now you have a case you want to appeal. How do you start? What is it? What are the steps in filing an appeal?
So the process starts after a judgment has been delivered by the trial court. And what normally happens is that the presiding judge or court would inform the parties, maybe in this case the accused person, that he has a right of appeal where there is a conviction and a sentence within 14 days. That is very important. The accused person must be made aware that he has 14 days within which to file an appeal. Now, what then happens is that the accused person, through his lawyer, would ask for proceedings to be typed. That is the proceedings of the trial. To be typed for purposes of preparing a record of appeal. And that has to be done in order to then have this record taken to the appellate court. Then the accused person is required to file a petition of appeal within the 14 days allowed by the law. Yes.
So what if 14 days lapse and you haven't appealed?
The law allows for extension, and the courts have on more than one occasion allowed appeals to be filed out of time for good reason, because you must also satisfy the court why you are not able to file within
14 days.
the time frame given by the law.
Okay.
Yes.
So you've talked about for you to appeal, you have to wait for judgment to be passed. But then there's also the other one that is such a mouthful even for me, interlocutory appeals. Like you can fight for an appeal in the process of your trial. Does it happen?
Yes, as I said, the trial process itself has its features. And within the trial process, you may have occasions where decisions are made by the trial court. on one or two aspects that may arise in the course of the trial. So basically what you're asking is what happens if you're aggrieved by maybe an order or a decision made.
And you can't wait to the end of the
And
trial.
the trial is still ongoing.
Yes.
Now, what we have is a remedy, or it is called revision. Okay. And this is jurisdiction. The revisionary jurisdiction is vested in the High Court, which has a supervisory role over the subordinate courts. So now, where there are certain decisions that attract grievances, where a party feels, and this party can either be us or the accused person.
Yeah.
Where this occurs, we have the right to move the High Court for revision. It's actually called revision, not now an appeal.
Yeah, it's revision.
So we are moving this High Court, and you are saying there is this decision or this order that has been made by the trial court, which is contrary to the law. All right? Or contrary to the procedural requirements. And we therefore ask the High Court to redress, to right the wrong that has been occasioned by the trial court.
Okay.
So there are those instances, and each will depend on the peculiar circumstances of each case.
So just something has come to mind. Why can't I just say that the judge is wrong in some decision is made during my trial? I want another judge. Why can't I just say that and things go now according to plan? Why should I wait? Should I appeal?
If I go by the example you have given, if you say you do not want this judge, you are talking about asking a judge to recuse himself or herself from the case. You must give reasons. Yes, it happens sometimes where you feel a judge
is unfair.
Demeanor perhaps is such that you feel you are not going to get a fair trial. But again, these are matters that are specific to each case. And you must give your reasons. It could be maybe through a comment made by the trial judge, or through, certain orders. It is allowed in law to ask a judge to recuse himself or herself. And where there are credible grounds adduced, then the magistrate may recuse himself. Yes, it's all about
So then you avoid
fairness.
the whole appeal process.
No, that may not affect the outcome of your case.
Okay.
Because your case is about evidence.
Yes.
It doesn't really mean that you are likely to get your preferred outcome maybe by going to another
Maybe
court.
I'm looking for a preferred outcome, actually.
That is forum shopping. No, that won't help.
It's not possible. So then I have appealed. I have done this within 14 days. And I've supplied the court with everything I need for an appeal to take place. So then what happens next? Is there a period of time that my case will be appealed, or is it again open-ended? I mean, what happens?
Now, once an appeal has been filed, and the record has been filed and served on the parties, now the law allows that appellate court to summarily allow the appeal, where the judge looks at the record and determines that the appeal is meritorious.
Meritorious inamaanisha?
Meritorious means the appeal has got good grounds. The reasons that you have given for appeal are plausible. In other words, you have got strong
for
grounds.
appeal.
Yes. Where it is clear that there were errors, because the appeal process is about correcting the errors that are done by the lower courts, either through wrong interpretation of the law or flouting of procedural requirements. So where these are clear to the judge that this ought not to have happened, then the appellate judge can summarily allow the appeal. In other words, the appeal can succeed. Then the appellate court also can summarily reject, in other words, without hearing the parties. You see, when I'm talking about summarily allowance or dismissal, I mean a scenario where the judge deals with these matters in the absence of the parties. Okay?
Yeah.
So where a judge also can look at the record and say, this appeal lacks merit. You know, there is really no strong ground. Everything was done in accordance with the law, the tenets of the law, and therefore this appeal is simply maybe an afterthought and can summarily reject the appeal. But again, you know, that attracts also an appellate right. You can still appeal now to the higher court.
Oh, it can be rejected, yeah, and then you still go to a higher court.
You can still go to the higher court.
Oh.
The appeal process ends at the highest court.
Oh, okay. Interesting. And I know we talked about the hierarchy of the courts, and earlier on we talked about our famous election petition, that it went straight to the Supreme Court, which is the highest court of the land. So how is it possible? Why didn't it go through the hierarchy?
Now, the Supreme Court, as a creature of the Constitution, is a special court. And presidential elections are not ordinary
cases or what?
Proceedings, if you like.
Yeah.
So petitions at that level are special. And you can imagine a scenario where if we allowed the appeal process in such, we will bring the country to a standstill.
Yes.
Yes, because you know this will drag on and on and on, and you know we may not have the time for that.
Yeah.
So it was established for a particular purpose, and that is one of the main purpose, that presidential elections
go straight there,
can only be determined at the Supreme Court, whose decision then is final. Yes.
Interesting. At least now you understand the court hierarchy. I bet somebody would ask, why didn't we start from the magistrate court going up, you know?
The Constitution and the law is very clear that election petitions can only be heard by the highest court in the land, and of course within the time frame that you know. Yes.
So I don't know whether it is just possible to improve the quality of trials at the lower courts so that time is saved, so that not the appeal process really is not necessary. Why can't we just then improve the quality of the trials we have?
Absolutely. You are right. And this is what we endeavor to do. You know that as an office, we have policies, we have guidelines now. For example, the guidelines on the decision to charge.
Yes.
We have the diversion policies. We have plea bargaining. All these are mechanisms that are geared towards ensuring that we have trials that pass the test of fairness. As an office, you know, we are, our sole aim is not to convict people, to see that people go to jail.
But you're gladiators, you are out to draw blood.
It is a wrong impression and perception that the public may have.
Yeah.
But we are there to do justice. All right?
Yeah.
We are there to represent the public. And this is why when sometimes offenses occur and they are investigated, they are brought to us for decisions to be made as to whether these people should be charged or not.
Yeah.
We look at them and say, we do not think that the evidence as gathered has met the threshold for prosecution. And this is where we have now the diversion policies. Okay?
Yeah.
And also we have plea bargaining. So we initiate those areas. And you can see that we do not want people to go to jail all the time.
We'll try and believe that.
Yes.
Okay. So somebody is asking here.
The example you gave,
yes.
that we have taken people to clean up the streets.
Yes.
You know.
That's a very good gesture, actually.
Yes.
Yes. Non-custodial sentence.
Yes.
I'm also learning these terms, these
Yes.
lawyer terms. Yeah, that's good. So I want to ask a question from our online viewers. Someone called Patroba has asked, tell us about, have we talked about revision? Tell us about revision. What application do we make?
Now, revision is normally invoked in a very informal manner sometimes. You can actually do a letter to the High Court asking for the High Court to revise the particular orders that you are aggrieved with. You can also do a formal application. Sometimes people or the lawyers represent the accused person file some sort of formal applications. You can also, through, for example, these days the victims are also taking part in the trial process. So sometimes also the victims may move the High Court also for certain orders. And therefore, the High Court will be seized of the matter and deal with the matter accordingly. It's also important to understand that the High Court has got jurisdiction, in fact, inherent jurisdiction to supervise the proceedings in the lower court. So the High Court can, on its own motion, call for the record of the lower court and look at it at the proceedings and see whether they are meeting the procedural requirements as well as the law requirements. Yes.
Okay. I hope, Patroba, you have been answered. Thank you so much, Abdi Issa. Thank you, Sarah. Thank you, Lillian, for following with us. Robert Mukundi, you've seen your question. I don't think it's prudent to discuss a case that is in the court, right? Somebody has asked why Babu has not been convicted to date. I know we spoke about that earlier. I mean, I don't know. Is there anything you want to say about that?
The case is still ongoing.
Ongoing. We wait. We wait. Yeah, Robert, you have gotten an answer there. So we'll just continue again, Mr. Hassan, and thank you so much for being very clear in your responses to us. Is there a cost to appealing? I mean, are you charged anything? Do you pay?
No, there's no cost. There's no filing fees that is paid to the court.
So how do you ensure it's not an abused process then? Because if it is free, and this is Kenya, we like free things. You can waste the court's time by just appealing and appealing.
That is why I talked about the court having powers to summarily reject the appeals, and dismiss those appeals.
Okay.
Where those appeals are found to be frivolous, okay, that they are of no merit, they are simply clogging the court system, the appellate court has these powers to summarily reject those appeals.
Good. So then, if you're not appealing, what are the other mechanisms that are available?
Yes, I talked about revision.
Yes.
Yeah, that is where you want to interfere with the decision of a lower court in one way or the other. Of course, you have the appeals process, and then you have the revision that we have talked about. Then you also have judicial review, which is a redress available to parties, where you are asking the court to look at the processes that public bodies have been engaged in. Sometimes that the effect of this judicial review process will end up affecting the decision that you are aggrieved about.
I don't think that one is clear, that judicial review. Maybe break it down a bit.
Judicial review is more or less defined and provided for in law. In fact, our constitution talks about it. The Civil Procedure Act also has a provision for judicial review. So revision in the criminal trial process, as I said, is a bit informal. You could do by way of a letter and all that. Now, judicial review is a power vested in the High Court to supervise or to examine the processes of the decisions made by public bodies. For example, tribunals.
Oh, that is just for public bodies.
It's for public bodies.
Okay.
Yeah, for example, you can have, if you have a gun and your license is withdrawn, there is a process where it says, you know, you can appeal to the minister. Suppose now the minister refuses, you know, to give back your gun, you can go to the judicial review. Now, we have also had cases where, for example, insofar as criminal cases are concerned, where parties have gone to court to say, from the evidence that we have, we think this criminal process ought not to have been commenced in the first place, because maybe the DPP had given word that, you know, I will not charge you, or you will not be charged. And then for some reason, somebody has been charged. So what happens is that people go to court and say, you know, there was this promise that I should not be charged, but I've been charged. And the courts, in some instances, have agreed. Yes.
Okay.
So it is more of a civil remedy than a criminal
remedy, one.
Yes, in that context.
Okay. All right. So the process is ongoing. My case has been heard at the High Court. I have won it. So what happens when I win an appeal?
Winning an appeal means that the decision that you appeal against has been interfered with. If you are convicted and sentenced to serve, say, 20 years in prison, and you have won that appeal, if you appeal against the conviction and the sentence, then you are set free.
Oh.
Okay?
Yeah.
Or you could have your sentence reduced. If you are jailed for 30 years,
you're given 10.
You could have your you could have it reduced to 10. Okay. You could have a new trial.
Okay.
Where the trial was found to have been tainted with a bit of illegalities, flouting of the procedure and the law.
So you're taken back. You're taken back to the lower courts.
You can have a retrial.
Okay.
Yes.
So you can go back to the lower courts with the same judge, now following process.
Sometimes there are normally specific orders that this particular case should be heard by
a different
magistrate.
Magistrate.
Trial court, yes.
Okay. Quite interesting. So what happens when you lose? Then
the conviction stands, the sentence stands.
Or you go back and continue with your case in the lower courts?
The conviction stands and the sentence stands.
Okay, wow. Anyway, I have a question here again from someone. I know we are going to have a discussion on plea bargains later in the show, not today, but someone has asked, and I hope you can address this. Can we hear more on the issue of plea bargain vis-a-vis murder cases and the involvement of victims' family? And I believe this again is related to the case we were discussing earlier. So I don't know whether we can handle it here or we let it rest.
It's a fairly deep area,
yes,
which requires a little bit more time than what we have here today.
Yes.
He's talked about the victims' concerns and family.
Yes.
Now the law, the new jurisprudence that is coming up is that the victims are no longer passive actors. Recently, there was a decision from the Supreme Court that gave guidelines on how the victims can now participate in the trial process. So their views and concerns have become very important and are of paramount importance. So that as I said, requires another session.
Yeah.
But plea bargain, again, as you said, you're going to have a session, takes into account the victim's concerns. Okay. But remember that in plea bargaining, the offenders are required also to own up to their misconduct. You cannot have plea bargaining where the victim
is still accusing
is still saying that he's innocent, that he didn't do nothing wrong. So there are those.
You have to accept your mistake.
Yes.
Okay.
You know.
Yeah.
And of course, the law must always take its course. It is not an avenue for getting out of jail through the back door. Yes.
Important.
It is important that you must honor and of course with the victim's concurrence and the court's concurrence, because plea bargaining agreements also have to be sanctioned by the court, because As I said, there should not be an avenue for sidestepping the intent, the letter and the spirit of the law. Yes.
Okay. So I have another question. Bonnie has asked, Counsel, kindly mention something to do with the resentencing in the High Court, which is taking room of appeals in most courts. I don't know if that is clear. There are more petitions based on the Francis Muruatetu decision nowadays as opposed to appeals. So Bonnie has asked that.
That's a good question, and it is something that has now taken root. That is the Muruatetu principle.
First of all, what is the Muruatetu principle?
Now, this was a case in the Supreme Court where Muruatetu and his colleague had petitioned the Supreme Court on the constitutionality of the death penalty. That is the mandatory nature of the death penalty under Section 204. They petitioned the Supreme Court and said that the mandatory nature is unconstitutional. That is because that section says any person convicted of murder shall be sentenced to death. So there was no other sentence provided for death, for murder.
For murder, it was death.
Yes, if you are guilty of murder, you must be sentenced to death. So they petitioned the Supreme Court and said, this is unconstitutional. And the Supreme Court agreed and said that the mandatory nature is unconstitutional. In other words, courts should have discretion. Not all murder cases ought to end up in the death of the offenders.
On death row.
On death row. So courts must be given some discretion. And this is, of course, impacted by what happens in other jurisdictions where you have different categories. You have, for example, murder in the first degree, murder in the second degree, and the sentences are meted out according to the grievous nature of the offense. So that is what Muruatetu said. Now, for resentencing to occur, there must be some sort of an appellate process. Because the people who are now seeking resentencing are moving the courts either through appeals or now petitions. Okay? You'll find that murder, which is tried in the High Court, in the instances where now the victims have been, the accused persons have been sentenced, they appeal to the High Court on the Muruatetu principle, saying that I've been sentenced to death, for example, but Muruatetu, say that I don't have to die, So still the resentencing happens because of this appellate process. We have a situation right now where we have people on death row and they had exhausted the appeal process. Now, what happens to them? Now, those are the ones who are moving now the court through various means, through actually petitions, saying that, yes, I'm on death row, but this is what the Supreme Court has said. Are you therefore able to look at this and substitute the death penalty maybe for the time that I've already served, or give me a custodial sentence? So it is happening.
So a custodial sentence can mean life?
Not necessarily life. Yes.
Been given 200 years.
But you see, 200 years, if you are lucky and you are able to live for 200 years, you'll come out after the 200 years.
Okay. Oh, good. Thanks for watching, Clement. Thank you, Abdikadir, Becky, and Ian. Thank you so much for engaging with us. We'll answer questions as they come. But now you've talked about people who have exhausted their rights, their appeal. How many times can you appeal?
As I said, we have the hierarchy of the court system in our country. If the trial started in the lower court, that is the magistrate court, you have the right of appeal to the High Court, to the Court of Appeal, and now to the Supreme Court. But now the Supreme Court has limitations. You can only appeal to the Supreme Court on a matter touching on the interpretation of the constitutional provisions. So if there is something within the trial system that calls for constitutional interpretation and decisions are made on that, and the party is aggrieved, you can move the Supreme Court. The other ground that can move the Supreme Court to exercise its jurisdiction is where there is a matter of grave national importance, a matter of public nature that is so grave that requires the Supreme Court's involvement. And as you know, the Supreme Court also gives advisory opinions. So there is a bit of blockade insofar as accessing the Supreme Court is concerned. We used to have the Court of Appeal as the last court. In fact, going by the name, Court of Appeal.
Yeah.
So that was the last court. And of course, the distinguished ladies and gentlemen that compose that court are known for their prowess in matters of law, and their decisions were final and oftentimes would be accepted by the parties.
Yeah.
Yes.
Okay. So Esther Chebet is asking, what if the convict did not exhaust the appeal process in a murder case, but comes back to the High Court for resentencing? So clearly this resentencing still needs some education on it.
As I said, if you allow me,
yes,
the Supreme Court, in deciding the Muruatetu case, had given certain directions and had actually asked that there be a task force that was actually set up to look at amending our laws insofar as the mandatory nature of the death penalty is concerned, and also life sentence, and then going about the resentencing processes now. So that task force was formed, and it has given its recommendations, which are yet to be fully enacted. One of the recommendations in the task force was that there be a committee constituted to be headed, I think, by a High Court judge, to go around the country looking at the resentencing aspect. So as we speak, there's a bit of work that is unfinished. Okay. But now what has happened is that certain people on death row decided to move the High Court, as for example, in the example that you have given, for resentencing.
So wait, Muruatetu was a guy on death row?
Yes.
Okay, because some of us are interacting with this name for the first time. So Muruatetu was on death row, then he went to appeal the sentencing at the Supreme Court.
On the constitutionality of the mandatory nature of the death penalty.
Okay, I get it. Okay.
Yes.
Yes.
So when we raised a bit of concern that why don't we await the recommendations implementation of the task force, so that we have a formal way of how to go about resentencing. In other words, you're looking at those people who are on death row. The position taken by the High Court was that the doors of justice are forever open. Why wait when we already know the jurisprudence, that is the position with respect to the mandatory nature? And the courts then will proceed to determine those matters in the manner that they were determined. And even the Court of Appeal has also moved on and said, we know what the position is. We know now that the mandatory nature of the death penalty has been declared unconstitutional. So those who are on death row should be, as a matter of justice, as a matter of fairness, be allowed to enjoy the fruits of this jurisprudence. Yes. So it's a gray area, if you allow me, and we are still trying to see how best to go about this resentencing, because it's a bit messy, if you allow me to say that, because we don't have a definite formal way of addressing this. But the cases that are ongoing right now are being done with that case in mind, and we are moving on quite well. And we only have death penalties where they are deserved.
Okay.
Because sometimes the nature of the offense demands that death penalty must be meted out. In fact, the Supreme Court itself said that they have not outlawed the death penalty. It is still there. All that is required is for the judge to have this discretion to see the aggravated nature of this offense. Does it require death penalty or not? And this is why you have people who are being sentenced to death, and you have others who are sentenced to 30, 40, 50 years in prison.
All right. A question again here. Do appeals have jurisdiction? Like, can one be dissatisfied with the decision of a lower court in Mombasa, but appeal in a Nyeri court?
Jurisdiction is important, and it's both the geographical and it's a matter of law. That will amount to forum shopping. Because why would you want to go to Nyeri, yet they are
from Mombasa
in Mombasa?
Yeah.
Yes, so you can't do that. Of course, people are allowed to apply for transfers of cases for reasons that are allowed in law. But you cannot do that. It's not for you to choose. Normally, you go to the if there is no that court within your geographical area, you go to the nearest.
To the nearest.
Yes, that's also for purposes of course accessibility and costs. Implications. Yes.
All right. So somebody else has asked again, how do we petition for new trial at the High Court? What application do we make?
The Constitution allows where you have exhausted your trial and the appellate process. I think Article 50. Sub 6 or 8 there, you can apply for a revisit to your case where you have come across new and compelling evidence which was not available at the time the trial was going on. So the law and actually the Constitution allows you to reopen your case where you've come now across evidence which was not available at the time the trial was going on, and which could not be reasonably accessed through due diligence. Yes.
Okay. Interesting. So you say the cost of appeal, it is free to file for an appeal. So the cost is between you and your lawyer. That is where you spend your money.
Yes. If you are able to afford a lawyer, then you do so. If you are not able to, for example, for murder trials and at the Court of Appeal, counsels are normally assigned to those who are not able to afford counsels. Counsels are assigned through pauper briefs and such like mechanisms, allowed to have counsels to represent them.
Can the court assign a lawyer for me when I want to appeal? Assuming I have no lawyer to help me in the appeal process, can I ask the court to assign a lawyer to me?
Not the court, as in that particular court, but at the judiciary, I think, through the registrar. And I think we have entities such as Kituo cha Sheria, and there are lawyers who are doing pro bono cases. So legal representation is very, very important in the criminal trial process. And actually is one of the grounds of appeal that you will come across. You know, people will be saying, I didn't have proper legal representation. I therefore didn't understand what was going on. One major, for example, ground of appeal is where a person pleaded guilty and then he was sentenced accordingly. Now, you know, if you plead guilty, the law does not allow you to appeal. If you appeal, those are the frivolous appeals and they'll be summarily rejected. So because you pleaded guilty, but then you'll find that somebody appeals and says, I don't understand. Maybe even the language that was used. I just said, yes, I understand, because the facts are read and you say they are true. And then later you say, I actually didn't understand. or the facts that were read perhaps do not constitute an offense, or they constitute an offense that is not known in law. So where you have a plea which is not unequivocal, people appeal on that. Now that's where legal representation comes in, because if this person had a lawyer, that lawyer would have been able to explain that there's something not right about this charge. Either the facts are not, disclosing any known offense, or the facts disclose a separate offense, that kind of a scenario. So legal representation is very, very, very important. Yeah.
So now we look at you prosecutors as alligators, gladiators, drawing blood, but then you say you're here, you represent the public in all your operations. So that means that the DPP can file for an appeal, right? And if then the DPP can do that, there's a process. Is it the same process?
It is the same process. There's no special process for the DPP. It is the same process. We appeal where we feel that the sentence, for example, was too lenient. We also appeal where we find that there was sufficient evidence, but the person has been let to go scot-free. Because remember, it's public safety here. When a person who poses danger to the society is released, we have to be concerned. And we will feel that we need to protect the society, and we will file an appeal. But just also to show you that we are not excited by sending people to jail. The law allows us to also, and it has happened, where we write to the appellate court to say that we are not supporting the conviction. Okay, fine. There was a conviction, but looking at the record, and after a serious analysis, we find that the conviction was not safe, and therefore we ask the court to, in other words, allow the appeal. So we do not derive any joy in fighting so hard to see that people are taken to prison. We are also, as a matter of also practice and law, also allowed to write to the appellate court, even where, for example, we find that the conviction perhaps was not correct, or even correct. We write to the court and say, we would like you to raise or to discuss or to canvass a very serious issue of public importance. And therefore, you give declarations, you decide on this aspect, which will then have a binding effect on the lower court. In other words, setting the record straight, so that the lower courts will now know that this is the way to go. It could be an issue of law, could be an issue of fact. So we ask these courts. So ours is, as I said, we are ministers of justice. Justice is our overriding concern. So even where we see there are certain gray areas, we will ask the courts to make those gray areas as white as snow.
Okay, so what if you say again the DPP and the ODP is here for public interest? Can you claim that you have killed for public interest? I mean, did you see the case? I think the woman in Siaya, the husband battered her, the husband made her life on earth hell. She killed. She was sentenced to 1 day. Wasn't that? Did she not help society?
That's an interesting aspect you are raising. As I said, in an adversarial system, you have two protagonists here.
Yes.
And as I said, it is on very rare occasions that you will find that we are in consonance with the decision of the court. In this case, you should have asked me whether we are happy with the 1 day sentence. I think that should have been the pertinent question.
That is a good question. But the question is, the person who was killed was found to be...
we're talking about the end result of that case. Or are we happy with the 1 day sentence?
So are you happy with the 1 day sentence?
As I said, sometimes it's not very prudent to talk about cases that are in court. Some will say we are unhappy. The victims, will say they are unhappy. Okay?
Yeah.
So what happens in such a scenario? We may be compelled to seek redress. And this is why we have this appellate system.
Yeah.
If you ask about my personal view about that particular case, I would say that maybe the 1-day sentence was too lenient in the circumstances. But again, you also need to look at the case. And the victims would be perfectly in order to say, let us take this matter for further judicial examination to the higher court. So I will not be surprised if that matter
goes to a higher court,
ends up in the Court of Appeal.
Okay.
Because I would not want to discuss the merits and the demerits here of whether the appeal will be successful or not. But there are those concerns, and there could be genuine concerns.
Yeah.
I could be of the view that having been in custody maybe for the time that she was in custody, if she was not out on bail, she may have learned her lesson. And the judge, in the wisdom, after looking at all the circumstances surrounding the case, further she had learned her lesson, and therefore there was no need for custodial sentence. So a lot also depended on the specific cases of the nature.
Yeah, I just asked that because it was a whole discussion on social about whether.
I know.
So it was just good to discuss
that.
Yes. Yeah. So finally, you are just not a prosecutor every day. What do you do when you're free, when you're not in court? Appealing.
Well, as a person in charge of the
and actually someone has asked here on social if you can talk about mitigation as regards the CIA case, and I believe it's the same case of the lady. So it is something that has gotten people talking a lot. Yes, so finally, before I ask you another question here, what do you do in your free time? How do you relax?
You're asking me what I do in my free time?
In your free time.
Free time?
Yes.
I spend a lot of that free time with my family.
Oh, good.
And I think the good side about this pandemic, if at all there's a good side,
if at all,
may the good Lord protect us all, is that during the lockdown, we were able in some way to really connect with our family members.
Yes.
And that connection, I think, keeps on growing stronger.
Yeah.
So I find that I spend a lot of my time with my family. Again, as an appellate prosecutor, I try to keep myself
updated
with the latest decisions from especially the Court of Appeal and the Supreme Court as far as criminal justice system or jurisprudence is concerned.
Okay.
So I do a bit of research here and there, and also, of course, from other jurisdictions. So I do a bit of reading in my free time, as you say.
Okay.
Yes.
That's good. I have a question here, and I know this is as we wind up. Someone has asked quite a long one. Sometimes youth are arrested and taken to court with charges like drunk and disorderly, and sometimes it's just because you couldn't bribe the arresting officer. Someone is always just expected to plead guilty in court. Can you appeal such a decision? And then number two, people who cannot afford legal representation and don't know about their right to representation and are sentenced without right of fair hearing, how can they appeal such sentences? I think we said it can be one of the grounds for appeal that you are not legally represented in
Absolutely.
the case. Yeah.
And what happens is that the accused persons are normally notified that they have a right to legal representation, and this is something that they ought to think about. About the other issue of drunk and disorderly.
Yes. You're just expected to plead guilty.
This is where we have diversion policies.
Yes.
We may take them to court, we may not take them to court.
And diversion is not bribing.
No, diversion is a
whole different thing.
It's a mechanism that is perfectly allowed in law, in order for these misdemeanors to avoid, because some of these offenses attract custodial sentences of say 3, 4, 6 months. So instead of sending people to clog our prison facilities, we can invoke other mechanisms. But keeping in mind that offenders must be held accountable.
Okay.
For us to have a just and a safe
Society.
Yes. Okay. Nobody should get the impression that they can go scot-free. You know, you commit an offense and life goes on the same way. Remember, they are victims. Your actions have consequences
On people.
for which you must be
held accountable.
Yes.
Okay. That's a good ending to our show today. Thank you very much, Hassan. I've seen someone here said you're a great teacher. Maybe you should consider coming back to continue teaching us about appeals. Looks like it was a very interesting topic for people. I'll just mention a few. Joe, thank you very much. Patroba, thank you for being a good student. These were students who were asking questions. There's Esther Chebet. I mentioned Abdikadir earlier. And of course, John and Michael, thank you very much for engaging with us. You can still ask and we'll get your questions answered too on social as you go along, because this is quite an interesting topic for us. We've come to an end to this show, Hassan, and thank you very much once again. You're the first gentleman on the show. The other guests before ladies. You honored us today as the first gentleman on the show.
I'm truly honored
Yes.
that I was chosen to be the first gentleman.
Yes.
I hear now there's a first gentleman in Tanzania.
Yes.
Maybe
maybe you should come, yeah?
You never know.
Yeah.
In future, I may be strictly so-called first gentleman.
Maybe you'll own the title one day.
Thank you very much.
Yes. Yeah. So we've come to the end of the show. Thank you very much for engaging with us on social. We are on Facebook, we're on Twitter, and we are still available to engage with you if you have any more questions. The day has come to our show has come to an end, and we invite you again next week. Even you again now, you can tune in and watch us and engage with us on our next topic next week, on the topic we'll be discussing next week on the show. Thank you once again. Have a great weekend and have a great Friday ahead.